Ready, start. In fact, it is this mini trial that would affect the right of the person sought to be arraigned as an accused rather than not having any cross examination at all. For, in light of subsection within bracket 4 of section 319 CRPC, the person would be entitled to a fresh trial where he would have all the rights, including the right to cross examine prosecution witnesses and examine defense witnesses and advance his arguments upon the same. Therefore, even on the basis of examination in chief, the court or the magistrate can proceed against a person as long as the court is satisfied that the evidence appearing against such person is such that it prima facie necessitates bringing such person to face trial. In fact, examination in chief untested by cross examination undoubtedly in itself is an evidence. Further, in our opinion, there does not seem to be any logic behind waiting till the cross examination of the witness is over. It is to be kept in mind that at the time of exercise of power under section 319 CRPC, the person sought to be arraigned as an accused is in no way participating in the trial. Even if the cross examination is to be taken into consideration, the person sought to be arraigned as an accused cannot cross examine the witness prior to passing of an order under section 319 CRPC, as such a procedure is not contemplated by CRPC. Secondly, invariably the state would not oppose or object to naming of more persons as an accused, as it would only help the prosecution in completing the chain of evidence unless the witness is obliterating the role of persons already facing trial. More so, section 299 CRPC enables the court to record evidence in absence of the accused in the circumstances mentioned therein. Thus, in view of the above, we hold that power under section 319 CRPC can be exercised at the stage of completion of examination in chief, and the court does not need to wait till the said evidence is tested on cross examination, for it is the satisfaction of the court which can be gathered from the reasons recorded by the court in respect of complicity of some other person not facing the trial in the offense. The power under section 319 of the CRPC is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offense. Only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised, and not in a casual and cavalier manner. Thus, we hold that though only a prima facie case is to be established from the evidence laid before the court, not necessarily tested on the anvil of cross examination, it requires much stronger evidence than mere probability of his complicity.